the Constitutional Court delivered a parole judgment that opened wounds and pushed the country back into the uncertain early years of our democracy. It was the granting of parole for convicted killer of Chris Hani, Polish immigrant Janusz Walusz, that triggered a fresh discourse on the issue. Dr. Sithembiso Bhengu is the director of the Chris Hani Institute and joins us tonight. Thank you so much for your time. In your protest response to this, you say it was a myopic and mechanical interpretation of the law which doesn't take into cognizance the politics and this, where society in South Africa is right now. Share with our viewers why you believe this.
Thank you very much. Essentially, our issue and the main issue is that we believe that the text and the reading of the judgment in many ways seems to only want to apply an interpretation of the law around remorse that seems to only be mechanical and not take into cognizance primarily the victims of what the crime was. We do believe that what is significant is that the crime of murder, for instance, as a general case, is not similar, for instance, to a crime of entering a bank, stealing money, where there's no victim. In this case, there is a specific victim. And in this case, the victims primarily will be the Hani family, obviously this is South African Communist Party and many others. And so the notion that conditions for parole are met that do not take into cognizance the attitude of the victims, direct victims, for us seems to be quite a challenge.
I was going to ask you this last, but it ties in quite nicely with what you are saying now, because it follows then, Dr. Bhengu, that in your view, parole may then be very rarely applied, especially not in murder cases. Is that the overall submission that you're making?
It's not that parole may really should not be applied in the murder victims, but the issue of parole, one of the key conditions on parole, by the way, in South Africa, which is, by the way, a good innovation within the correctional services. For instance, there's a component where perpetrators meet with victims. And so one of the conditionalities around how parole is done, especially on the cases of where there is specific victims that are violated, whether it is murder, it is rape, all those kind of things. And so in this case, for some reason, it seems as if the notion of remorse is detached from whether the victims also express the view that the remorse is genuine or not.
Isn't the key distinguishing factor, based on what we know, and also, that really emotional and heartfelt response in reacting to this judgment from the family, the fact that there has not been full disclosure here, the fact that the opportunity for the family to come to some level of closure by understanding the course of events, who might have been behind the scenes, who ordered this, would that have gone a long way to perhaps changing the family, Hani's family's mind on this matter?
In their own attestation, that is primarily the gripe that the family seems to have on this case. In fact, we have heard and we know from the submission from the minister, by the way, on this case that the assassin wrote both an official apology as well as a personal apology to the family. By the way, what is normally not mentioned is that upon the receipt of that apology, there was a follow-up from the family around the request for disclosure. But that disclosure has never come. There was, by the way, this case was first heard in the Truth and Reconciliation Commission. Even there, the disclosure was never offered. And so this challenge of the issue of disclosure, and so the primary question is then, what then do we call remorse when the key conditions that allow the family some closure are not then met? What then is the difference between pretense and genuine remorse?
The family is taking real issue with, as you say, the way that the court, the court used what was at its disposal to apply its mind and then formulate a decision going to the letter and not the spirit of the law, I think, if I'm characterizing it correctly. And what you also say in your response is that the Hani family submission seemed to be more of a background matter to the apex court than rather, them seeing it as a pivotal and central contribution to the issue itself.
Yes, in fact, when you read both the summary of the text of the judgment, as well as reading the actual judgment itself as a whole, which we have read, it's very clear that the case is mostly premised on the submission by the applicant vis-a-vis the ministry. And so the actual mention of the case of the family in the summary is really just mentioned as a reference point, rather than actually engaging substantively around what are the claims that are being made by the family in their opposition to the case.
Do they feel the court has wounded them?
Yes, I think there is. Obviously, for those who watched the initial response, almost the kind of gut response, which, by the way, the family has retracted some of the words mentioned there, but that was a sense of the gut response of the disappointment in how it seems as if the constitutional judgment almost ignores what this case meant or means to them and the impact of it over the last, let's say, 25 to 29 years.
Well, what can the next steps be, Dr. Bhengu?
Well, obviously, another important thing I think it is good to make here, because a lot has been said then, are we then opposed to the Constitution, to the constitutionalism? And that is not the case. And part of the challenge, I think, that we have had over the last few days has been this conflation that a critique of one decision by the court is essentially a rejection of constitutionalism as a whole, which is not the case. And so we do know that there are legal processes that are there. Take, for instance, one possibility will be to apply for a review or a rescission of this judgment.
Such as the SABC is calling.
Exactly. And probably together with that also an application for the stay of judgment. And so there are still legal processes, and I think that is quite key to make, because it's not that in our opposition or in our displeasure, disappointment with the court case, we are rejecting the legal process. And so there's an understanding that there is a legal recourse that is still there. But obviously, the South African Communist Party, I suppose, in their specific case, as a political organization, they will also then want also to do political kind of actions that are in line. But that does not take away the fact that there is actually still very much legal processes that can be undertaken to remedy the situation.
You'll fight this till the end?
I believe so, yes.
Thank you for talking to us. It is an emotive subject, not only, of course, for the family, but for many quarters of South African society who, saw what happened at that very pivotal moment in our history and how that shadow continues to loom large on our democracy. Thanks for talking to us tonight, Dr. Sithembiso Bhengu, who is the director for the Chris Hani Institute.